My name is Branigan Robertson, and I'm an employment lawyer. This video is the ultimate guide to hostile work environment and harassment law. I'm about to explain workplace harassment without all the legal jargon. So if you want to know if you have a case for harassment and what it might be worth, then keep watching. Before we jump in, I have a few preliminary items to cover. First, this video will cover the following topics: the legal definition of a hostile work environment, examples of common harassment cases, what to do if you're still employed, you quit, or you were fired, the statutes of limitations, which is the deadline that you have in which to file your case, and at the end of the video, we'll cover how much money your case might be worth. Second, I use the terms hostile work environment and harassment interchangeably. I do this because 99% of the harassment cases we see fall within the hostile work environment umbrella. In the eyes of the law, these usually mean the same thing. Third, I will not be covering sexual harassment in this video. While all the principles certainly apply, I made a detailed video called Understanding Sexual Harassment that I would recommend if that is the situation you are facing. And fourth, in this video, I primarily discuss California law because that is where I have a license to practice law. However, this video is meant for everyone across America. If you are not in California, this video will help you identify critical questions that you should ask a lawyer in your state. If you are in California and you need a consultation, here's my contact information if you think I've earned your phone call. All right, let's get going. In California, the main anti-harassment law is California Government Code section 12940 subsection J. If you're not in California, Title VII is the federal anti-harassment law that applies to everyone across America. Here's what the California law says. Yes, I'm actually going to read the law to you. It is an unlawful employment practice for an employer because of a protected characteristic, which we'll cover here in a second, to harass an employee. It becomes unlawful if supervisors knew or should have known of the harassing conduct and failed to take appropriate corrective action. Subsection K goes on to say that it is unlawful for an employer to fail to take all reasonable steps to prevent harassment from occurring. But that's not the end of the story. The law also requires that the harassment be unwelcome, which means you didn't want it to happen. That might seem obvious, but it's actually sometimes very confusing in cases. The harassment also must be so severe or pervasive that a reasonable person in the victim's shoes would have considered it an abusive working environment. So to summarize, it is illegal for an employer to harass anyone because they have a protected characteristic. Again, we'll cover those in just a second. Before we get to the protected classes, I want to point out a few very important things. Look, I only read two small parts of 12940. There's a lot more to this body of law that I don't have time to get into in this short video. But if you want to know more about this area of law, go to my hostile work environment page on my website. I'll leave a link below. My website dives deep into the law. This California law applies to all employers who have at least one or more employees. The federal Title VII law applies to employers with 15 or more employees. So if you work for a small company that is below 15 employees and you're not in California, you might not be able to pursue your case, at least not under Title VII. Okay, so what are these mysterious protected characteristics in California? Because harassment isn't just sexual harassment. Harassment can be based on any one of these things. So real quickly, race, religion, color, national origin, ancestry, physical disability, mental disability, medical condition, genetic information, marital status, sex, which also includes sexual harassment, pregnancy, and related medical conditions, gender, gender identity, gender expression, age, if you're over the age of 40, sexual orientation, military status, and veteran status. This means that if somebody is harassing you because you have one of these characteristics, you may be a victim of unlawful harassment. Now, these are the California protected categories. The federal Title VII only protects race, color, religion, sex, which includes pregnancy, national origin, age, disability, and genetic information, I think. Each one of these categories has a very specific legal definition. So if you want to know if the harassment that you are facing falls into one of these categories, you need to call a lawyer. It's very important. Before we move on, let me talk you through a common looking example. Let's pretend you're female and you've been working a job for a few years with positive performance reviews. Suddenly, you get a new supervisor, and he makes it very clear that he believes that if women choose to work, they shouldn't get pregnant. He makes all sorts of derogatory comments towards working women who are pregnant and have small children, saying that they're not committed, they look sloppy, and they're somehow betraying their family. He actually makes fun of women in the same company in other departments who are pregnant, saying that he feels sorry for their managers. And it just so happens that a few months later, you become pregnant. As soon as he finds out, he starts excluding you from phone calls, micromanaging your tasks, writing you up for petty things, and just making your life miserable. Now, he doesn't say anything about your pregnancy directly to your face, but you already know that he hates it. Suddenly, you get put on a performance improvement plan with impossible goals to meet. And then 2 months later, when you don't meet those goals, he fires you. In this situation, if your lawyer can convince a jury that the real reason for your termination and the hostile work environment before that is your pregnancy, then you'll probably win your case. Obviously, in this example, you can easily swap out the protected characteristic for disability, race, religion, age, etc., and the principles would still apply. And if you are paying close attention to the example, you probably noticed that your boss never came out and said that he was firing you because you got pregnant. It's extremely rare in today's world to find that good of direct evidence in harassment cases that the company fired you for your protected characteristic. Rather, it's your lawyer's job to prove that the real reason for your termination was your protected characteristic. In this case, that would be your pregnancy. The termination lie that you didn't meet the performance improvement plan is called a pretext. And I've made an entire video on pretext. I highly recommend that you watch that video once this one is done. I'll put a link below. Well, okay, Branigan, what should I do if I'm currently experiencing a hostile work environment? Generally, my advice changes depending on whether the person I'm speaking with was fired, if they quit, or if they're still employed. Let's look at all three of those situations. If you're still employed, unless extraordinary circumstances apply, I generally don't recommend hiring legal counsel and blasting your company with a nasty letter or a lawsuit. And I'll explain why in just a second. Generally, I recommend that employees send a polite, respectful, and helpful written complaint to the appropriate authority at your company. I made a detailed video on how to complain properly at work. So if you are being harassed right now at work, I highly recommend that you watch that video as soon as this one is over. I'll put a link below. Generally, lawyers like me tell people to call us after they get fired. That is the best time to hire a lawyer and take legal action. And I know that's not very helpful for the folks who are still employed, which I'm guessing is the majority of you watching this video. And I'm also assuming that a lot of the people who are watching this want to put a stop to the harassment and save their job because they don't want to lose their job. It's much better to have a good job than a good lawsuit. So why do we ask people to call us after they get fired? Well, there's two main reasons for this. First, the tools that the law has given employment lawyers like me are largely ineffective at stopping hostile work environments. Usually when a lawyer like me inserts myself into the middle of an ongoing employment relationship, we just make everything worse because it paints a big target on your back, and the company from that point forward will want you to fail. Lawyers like me are far more effective at pursuing justice after the fact and teaching the company a very painful lesson. Second, this concerns attorney's fees. Most employees simply don't have enough money to pay lawyers like me out of pocket. That's why we usually work on a contingency fee. We only get paid if we recover money for you first. Due to the amount of time and money it takes a lawyer like me to properly pursue a harassment case, the case simply must be worth a significant amount. And unfortunately, that usually means our clients have been fired. Now, there's always exceptions to this. So if extraordinary circumstances apply to you, my office would be happy to provide you with a consultation. Well, okay, what if you quit your job after getting fed up with a hostile work environment? These cases are pretty tough. California law says that unless your resignation qualifies as a constructive termination, you cannot collect your lost wages. This dramatically hurts the value of your case. Now, I've taken cases where my clients quit in the past, but in those situations, the harassment was truly extraordinary. So if you quit your job due to extraordinary harassment, call my office to see if your resignation may qualify as a constructive termination. Well, what exactly is a constructive termination? Unfortunately, I don't have time to get into it in this video, so if you quit and you want to know, either call my office for a consultation or go to my website, as I have lots of information on that subject there. When you hear lawyers talking about hostile work environments, you often hear us talk about things called the EEOC or the DFEH. What are these? These are government agencies that try to enforce workplace anti-harassment laws. The Equal Employment Opportunity Commission, or EEOC, is a federal agency, so it applies to everyone in the United States. Whereas the Department of Fair Employment and Housing, the DFEH, is a California agency, so it applies only to California employees. For purposes of this video, these two agencies do two main things. Number one, they actually pursue cases on behalf of employees, much like a private lawyer like me would do. And second, they are a gatekeeper. Before you can pursue your case in court, even with a private lawyer, you need to get a right to sue letter from one of these agencies in order to exhaust your administrative remedies. Now, if you have a good case and you hire a private lawyer like me, I will acquire the right to sue letter for you before we pursue your case in court. Having a lawyer get your right to sue letter is a smart move because people screw up the right to sue letter all the time. Generally, if you can find a good lawyer to take your case, you should pursue the case with the lawyer. These government agencies are simply overwhelmed with claims. Moreover, you rarely hear about the EEOC or the DFEH getting a large settlement or verdict on behalf of an employee. But if you can't find a lawyer to take your case, these agencies are a great option. In all areas of the law, we have deadlines, meaning you have to do something before the deadline comes. If you don't, your case goes goodbye. In California, these deadlines are called statutes of limitations. So you need to file your hostile work environment claim with the DFEH within 1 year of the last act of harassment. After you get your right to sue letter, you have 1 year in which to file your case in court. However, I recommend that you contact a lawyer right after severe harassment or a termination has taken place. This is because certain situations have complicated statutes. They overlap, and some of them require you to take action as quickly as 6 months. So don't wait, contact a lawyer ASAP. Outside of California, in general, you need to file a charge with the EEOC within 180 days from the last act of harassment. Once you receive your right to sue letter, you must file your lawsuit within 90 days in court. But again, do not wait this long. If you are the victim of serious harassment, contact a lawyer the next day. Don't wait months or years because likely you'll lose your chance entirely. Next, we are briefly going to cover how much harassment lawsuits can be worth. But before I do, please note, I made a detailed video on this exact subject. So if you're really curious about case value, go watch that video because I cover this stuff extensively. All right, you can recover 4 different types of damages: lost wages, pain and suffering, punitive damages, and attorney's fees. Let's talk about lost wages first. Lost wages are the lost salary, benefits, commissions, hourly wages, bonuses that you're no longer earning because you were terminated. For example, if you were making $45,000 a year and then you were harassed and fired, You're not making $45,000 a year anymore, but you can only recover these lost wages, which are also known as economic damages, if you are terminated. Unless extraordinary circumstances exist, the law doesn't let you recover these types of damages if you voluntarily quit or if you're still employed. Second, pain and suffering. Pain and suffering damages are for the emotional pain, humiliation, and mental suffering that you experience due to the hostile work environment. These damages are very real. In harassment cases, they can get extremely large, and you can't fake them. You're going to be evaluated by experts in front of a jury. So the amount of emotional distress damages that you will receive is decided by the jury. And please realize, two different juries can hear the exact same case and award two different amounts. But usually, in severe cases, the emotional distress damages are significantly larger than your lost wages. Third, punitive damages. Everybody's heard about punitive damages. These are the damages meant to punish the company for acting with malice, oppression, or fraud. These are rare, and you have to have a really good case to win these. Fourth, attorney's fees. In harassment cases, you can recover attorney fees on top of the other forms of damages if you go all the way to trial and you win. Now, this directly benefits you because the company could be on the hook for your attorney's fees, which in some cases can be several times larger than your damages. So this increases the settlement value of your case. And since the majority of cases settle, this is a good thing for the employee. All of this damage stuff is to say that some cases settle for millions of dollars, but most settle for a lot less than that. Every case is drastically different, so to get a realistic idea of what your case might be worth, unfortunately, you're going to have to contact a lawyer. I hope you found this video to be informative and helpful. If you are in California and you need a lawyer right now, here's my contact information. My office handles a lot of harassment cases, and I would be honored to evaluate your situation free of charge. Finally, if this video helped you in some small way, please consider giving it a thumbs up on YouTube and subscribe to my channel. If you know somebody who is currently experiencing a hostile work environment, please share this video with them. They will thank you for it. That is all I have for you. I hope you have a fantastic day.